Wenn Sie Bäume inaktiv wird, hast du das inaktiv das ist ein Auto, hast du das inaktiv Wie ist denn jetzt? Aber dann scheint hier die Browser-Variante zu sein, denn es ist inaktiv. Hier scheint die Browser-Variante zu sein, denn es ist inaktiv.
Шановні учасники, ми розпочнемо за 1 хвилинку. Будь ласка, залишайтеся з нами онлайн.
Participants,
We will start in 1 minute, so please stay with us.
Доброго дня всім учасникам сьогоднішньої
good morning to all participants of this meeting. Can everybody hear me well? Okay. Everybody can hear me. I am Olena Kalashnikova. I will be the moderator of the opening part and of the session 1 of this conference. I hope that technically you are all connected and you can take part in our conference, and I switch to beginning. Dear participants of the 4th Scientific and Practical Conference, Administrative Justice in Ukraine, Syrian Practice. With support of our partners, Council of Europe project, support of transparency, inclusion and of electoral process, and support of reform constitutional justice and provision of support to Верховна Рада in conducting reforms and raising its efficiency. OSCE project coordinator in Ukraine, German Foundation for International Legal Cooperation. This event, which is called Protection of Electoral Rights by Administrative Courts of Ukraine, we invited representatives of academic circles, courts, both administrative and other courts from all parts of Ukraine. I welcome participants of European countries from international organizations. Through the prism of human values, they will share their knowledge, their opinions, their views to identify problematic issues of protection of electoral rights on the basis of uniform system of electoral law in compliance with international standards to make conclusions for us that are very important, because these standards, these principles will become the basis for democracy, elections, electoral process, electoral law, electoral legislation. Connected with us are very important persons that now will make their welcoming speeches. I give the floor to President of Supreme Court, Madam Valentina Danishevska. Thank you very much. Dear ladies and gentlemen, I'm very pleased to welcome you at the conference organized by Supreme Court. Traditionally, it is devoted to protection of electoral rights. First of all, I want to thank all those who have joined our conference. The conference is held within the framework of annual days of administrative justice in Ukraine. In such a way, we show our support to historic events of 2005, when the Code of Administrative Justice was adopted by Верховна Рада, that laid legal foundations for protection of rights and freedoms of citizens and became a legal basis for the work of administrative courts in Ukraine. Today, I'm extremely pleased to see our colleagues and many years partners who provide support to Ukrainian courts to increase their capacity and development of justice. Our great thanks to OEC Project Coordinator Office in Ukraine, German Foundation for International Legal Cooperation, and Council of Europe Project Support on Transparency, Inclusive and Fairness of Electoral Process, and support constitutional legal reforms, constitutional justice, and providing support to Верховна Рада in conducting reforms aimed at raising their efficiency. Great thanks to our Ukrainian partners who got engaged to this event. First of all, National Academy of Legal Sciences of Ukraine, Taras Shevchenko National University, Ostroska Academy National University. I also show our respect to esteemed foreign guests. We welcome Mr. Stan Nyorlov, Head of the Council Europe Office in Ukraine, Madam Edith Zelle, Head of Association of European Administrative Courts, Mr. Kryzhavichus, Head of High Administrative Court of Lithuania, Mr. George Papuashvili, President of Constitutional Court of Georgia, retired expert of Venice Commission. Also, Mr. Yevgen Chuli, lawyer, Ukraine 2050 organization. Dr. Lars Brocker, President of Constitutional Judicial Chamber, Rheinland-Pfalz. Madam Marina Rusa, Judge of District Court from Moldova. And our old friend and partner, Stefan Hilshöster, Director of the German Foundation for International Legal Cooperation. I want to note our respect to Mr. Alexander Pedryshin, President of National Academy of Legal Sciences, Mr. Alexander Vodyanikov, National Legal Advisor of OEC Project Coordinator in Ukraine, Mr. Dmitro Tretyakov, lawyer, Secretariat of European Court of Human Rights, and our frequent guest and consultant, and Mr. Denis Kovrizhenko from IFES. I would like also to note many other respectful guests of our conference. First of all, those who prepared, I'm quite sure, very interesting presentation for our conference, but because of lack of time, I shall not name all lists. So our welcome to all of you from Supreme Court. The question of ensuring right of citizens to take part in elections is important for Ukraine, and I'm sure for all civilized states. Today we shall have unique opportunity to discuss key aspects of electoral process in the light of national and European experience. When considering disputes that arise in connection with election, the courts protect expression of free will and safeguard fundamental electoral rights. According to the position of European Court of Human Rights, functioning of effective system of protection of electoral rights in the court is the main safeguard of ensuring free and fair elections in Ukraine. That requires from judges proper and swift review of legal problems that arise in this sphere, as quite often even consideration of individual disputes impact the trust of electoral process in general, and hence recognition of election results in the state and abroad. Many problematic legal questions arise regarding electoral process connected with local elections and as regards nationwide election process. As statistics show, number of electoral disputes that come to courts remain mainly stable. Most of them concern the accuracy of voters' lists, although their share of all election cases tends to decrease. Other cases reviewed by courts concerns composition of electoral commissions, information support, election campaigning, and complaining against election results. I would like to draw your attention that most of electoral cases considered by Supreme Court almost always is getting broad coverage of mass media and causes great interest of the public, and they impact the level of public trust to election and public trust to courts. Last year, Electoral Code of Ukraine came into force. Supreme Court has already some experience of considering cases regarding local elections, but general conclusions could be made after we consider cases regarding nationwide election process. Today, it would be interesting to hear experience in Germany, Lithuania, and other European countries, as well as case law of European Court of Human Rights. And I'm quite sure that it will be useful for us to cope best way with all the problems that we face in electoral process, and trust to elections in Ukraine will be always high. In this context, I want to note the importance of conducting such thematical conference at which academics and practitioners can exchange opinions on different issues, and when possible to resolve problems connected with the drawbacks of electoral process, collisions of legislative regulation, and different approach to the interpretation of legal norms. I wish all participants of the conference a fruitful dialogue today, interesting presentation, and profound discussions. I will be interested to see the recommendations that will be approved based on the results of this event. So I wish you all a successful day and interesting professional dialogue. Thank you for your attention. Thank you, Valentina, for warm welcoming addresses. And we now switch to the next participant of the welcome session, Mikhailo Smukovich, Judge, President of Administrative Cassation Court, Doctor of Law. Good morning, Valentina Ivanovna. Good morning, all participants of our conference. Dear ladies and gentlemen, I am glad to welcome you all at the 4th International Scientific and Practical Conference regarding protection of electoral rights by administrative courts in Ukraine. I am very pleased to see that all our partners, the partners who were at the start of development of administrative justice could join the conference. As Madam Danishevska said, it was in 2005 that the destiny of protection of proper rights of people in territory of Ukraine by courts was decided when administrative justice appeared. And then all society who was well aware of that was working with Verkhovna Rada, at Verkhovna Rada, to enable approval of administrative code of Ukraine by overcoming the veto of the president of Ukraine, who didn't agree with some provisions of the code of administrative justice. I also joined the welcoming addresses and the words of gratitude to all participants, to all international institutions, to all our guests, named by Valentina Ivanovna Danishevska. Thank you all very much. Thanks from me personally and for all justices of Supreme Court, including Cassation, Administrative Court. Supreme Court is supporting such events, such conferences, starting from 2008. We celebrate Days of Administrative Justice in Ukraine that, among other things, include holding international conferences, international scientific and practical conference like the one that we are holding today. Normally, the topics for this conference are chosen by the chambers of Administrative Cassation Court, then after the other propose the topics. And the chamber on electoral cases, referenda, and protection of political rights, this chamber organized this conference second, and therefore I thank organizational committee, justices of this chamber of Supreme Court, and all staff of Secretariat of Administrative Court, including the staff of Supreme Court, who were engaged in preparation of this conference. One can see that the conference has been prepared at a very high level. The topic chosen is very important, as Valentina Ivanovna mentioned. Electoral right in a democratic state is the fundamental right, the basic right, I can say, because it's through this right every citizen of Ukraine, Ukrainian people, can govern the state, can control state authority. I'm very pleased to say that today, when we are present at the dissertation hearings, dissertations of different level, we see that scholars define protection of electoral rights as an important part of protection of law. Without the proper safeguard of electoral right, it is like an egg without a shell. It cannot exist at all. Such scientific considerations will be discussed today regarding electoral right. It's the jurisprudence of Administrative Court to review electoral cases. They have some experience, not only in Cassation Administrative Court, in the Grand Chamber, such cases were considered. So therefore, this topic, protection of electoral rights by administrative court, is so significant. I'm quite sure that it will be interesting for all of us at this conference. I'm quite convinced that based on the results of this conference, relevant recommendations will be elaborated to Верховна Rada regarding amendments to the legislation, regarding improvement of legislation. Such initiatives all the time are supported of Supreme Court, the President of the Court, Valentina Denishevska, because nobody else can see collisions in legislation, imperfections of legislation like courts. And this court disputes arise just because of these imperfections, and courts have to resolve these conflicts. On behalf of the organizational committee, on behalf of all engaged in the preparation of this conference, I want to welcome you at this important conference, and I want to announce our conference open. I wish all participants new discoveries, fruitful exchange of opinions, practical skills, and productive scientific inquiry. Thank you. I wish you fruitful work. Thank you, Mikhailo Ivanovich. And now I give the floor for welcoming address, Head of the Council of Europe Office in Ukraine, Mr. Stin Norlov.
Шановні пані та панове, від імені Ради Європи раді вітати усіх учасників та учасниць конференції, що присвячена питанню сутобого захисту виборчих прав громадян. Мені дуже приємно, що цей захід ми організовуємо спільно з нашим надійним партнером, Верховним судом та нашими іншими міжнародними і національними партнерами. Last year, we celebrated the 70th anniversary of the European Convention on Human Rights. Article 3 of Protocol number 1 to the Convention guarantees the right to free elections. This right is fundamental to the sustainable development of democracy. Due protection of electoral rights is an integral part of democracy. The role of courts in this process is key. The level of citizens' trust in the election results and the legitimacy of the elected authorities depend on the quality of court decisions. This we have seen worldwide. European electoral standards, including as regards election dispute resolutions, are primarily targeted to sustain the implementation of the basic principles of electoral law: universal, equal, free, secret, and direct suffrage. Compliance with these principles, amongst others, is ensured through the independence of the judiciary, and its activities should be transparent and focused on ensuring the rights and interests of the citizens. The Council of Europe provides its support to Ukrainian reforms, in particular electoral reform, in order that the European electoral standards and good practices are embedded in Ukrainian legislation and practice. This might include issues related to election management, election dispute resolution, regulation of political parties' activities and financing, media coverage of elections, ensuring balanced political participation and representation of women and men, and many other issues. We do systematically and actively support the Ukrainian national and local authorities, as well as Ukrainian society, to ensure that these reforms and these changes are implemented in accordance with European norms, principles, and standards. For more than 70 years, the Council of Europe, all its bodies and institutions, have worked to ensure due protection and promotion of human rights, democracy, and the rule of law in the Council of Europe member states. I would like to take this opportunity to thank all our partners for their dedication to electoral reform, improvement of electoral legislation and practice, as well as for cooperation in organizing this important event, which I hope we will have further follow-up afterwards. On behalf of the Council of Europe, I would like to reassure that we stand ready to continue providing any further necessary support and assistance in improving electoral legislation and practice in Ukraine. We hope that the discussions of existing European electoral standards and good practices, the case law of the European Court of Human Rights, as well as the lessons learned from the recent elections, will help to identify further possible direction and ways to improve the election dispute resolution in Ukraine. With this, I wish all conference participants an interesting and fruitful discussion the next 2 days. And I, as also mentioned by our honored judges, also look forward to seeing the recommendations, which hopefully will, as was mentioned, be the stepping stone for further work with the issue in collaboration with the legislative power of this country, the Verkhovna, amongst others. Thank you very much and have a good discussion.
Дуже дякуємо вам.
Thank you very much. It was a special pleasure to hear from you. You're perfect Ukrainian. We really appreciate that. Now I'm invited to the floor the National Advisor for Legal Matters OBC project in Ukraine, Mr. Alexander Vodyannikov. Please, the floor is yours. Esteemed head of Supreme Courts of Ukraine, esteemed justices of the Supreme Court, ladies and gentlemen. Last year we celebrated 70 years of European Convention of Human Rights, which was just mentioned by the ambassador of EU. But last year we also celebrated 30 years of Copenhagen document, which actually laid foundations or basic standards of acquis OSCE with regards to free and fair and democratic elections, which actually is now the sample for the electoral process all around the world. The electoral law has big importance for lawful state. In English-speaking literature, they call it the law of democracy. It's not for nothing, because it's very symbolic and very proper definition how this right is implemented, how it is protected by the courts, and how it exists in a specific state. But I'd like to mention something else. In the 21st century, after the totalitarian apogee, which was called by a British philosopher the policy of extremities, the period of democracy came with respect for human rights, and now constitutional democracy is undergoing some very dramatic changes. Democratic regimes that seemed to be unchangeable are suffering from manifestations of populism and xenophobia. We can observe some very dangerous trends concerning degradation of state and non-state institutions and transformation of the public power as such. All these are indicators of very interesting change of the paradigm which has been taking place for the last 20 years in the modern civilization. Damon, Stanford University professor, stated several years ago that for decades we had not seen anything similar. We cannot imagine how serious it is. I believe that these words depict this uncertainty that we observe in both academia and political communities with regard to changes taking place in the societies. What are the causes of this situation? Is the theory of cycle really truthful, and we are getting back to post-war period of the 20th century when the democracy was built on the ruins of European empires? Do our democratic regimes have sufficient resilience? Of course, the answer to this question is quite difficult, but I think one of the signs of resilience of a regime is its ability of the national judicial system to defend the democratic rights in the democratic electoral process. That's why the subject matter of this conference is extremely relevant, not only for Ukraine, but for Europe and the democratic world as a whole. To conclude, I'd like to stress that many OSCE projects are ready to provide support to the Supreme Court, and we'd like to sincerely thank the head of the Supreme Court and the Supreme Court for the cooperation that is implemented for purposes of further development of the Supreme Court, and we stay ready to support your initiatives within the framework of our projects. Please, esteemed receive our assurances of our readiness for further cooperation and interaction. Indeed, we are looking forward to the recommendations that will be developed during this scientific and practical dialogue that we expect to take place here. Thank you. Thank you very much, Alexander, for these words of support. Now the floor is offered to our old friend, Director of German Fund for International Legal Cooperation, Mr. Stefan Kurzfester. Please, the floor is yours.
Yeah, дуже вам вдячний.
Thank you very much.
Dear Mrs. President Aniszewska, dear Mr. President Smakovich, dear Mr. President of the National Academy of Legal Sciences, dear colleagues from the Council of Europe and the OSCE, ladies and gentlemen, and dear friends. First of all, I would like to thank you very much for being invited to this conference concerning the electoral law, an area of law and of Ukrainian administrative jurisdiction of utmost importance for democratization, for the rule of law, and for the society as a whole. Last week, together with the Venice Commission, with the OSCE, and with the Ukrainian Constitution Court, we had a conference on the 25th anniversary of the Ukrainian Constitution. This conference was dedicated to the rule of law principles incorporated and enshrined in the Constitution. And therefore, today's conference could be seen as a part or continuation of the above-mentioned constitutional law conference, because the electoral law, as it was said already, is part of the constitutional and democratic governance and state building. Elections reflect the political will. Elections form the parliamentary basis of a rule of law governed state. Elections and political bodies, and therefore the democratic process of forming the political will, can be severely damaged by strategic deforming of the electoral law by disregarding electoral rules. Elections are for every country and for every society the democratic essence. And we in Germany are facing elections in September this year, and we are in the lucky position that all in all we have a very good functioning electoral system, that we have common sense and understanding of the meaning of elections. Nevertheless, Of course, we have a system controlling elections as well. And once you don't have that common sense and that common understanding, you all the more need a corrective, an instance, and guard controlling the observance of electoral rules. For Ukraine, it then was a wise decision to introduce an administrative jurisdiction dealing also with the questions of electoral law. Administrative courts are sometimes called little brother or little sister of the constitutional courts. That's a strong signal for its importance and its value. But in general, it's not only the court system, it's each single judge with his full independence who's taking care of these democratic core values. Especially in this field, administrative judges sometimes need a strong backbone to withstand and to resist any attempts of influence. That exactly were the reasons why the German Foundation for International Legal Cooperation started its cooperation with Ukraine already at the beginning of the 90s. And besides of constitutional law, of civil and economic law, another main focus was on administrative law and administrative jurisdiction. Until today, we have quite close and meanwhile also very practice-oriented cooperation between German and Ukrainian administrative courts. And I think it's quite successful cooperation. And success means people and experts contributing to long-lasting efforts. Mrs. President Danishevska herself and Mr. President Smakovich himself are such experts from Ukrainian side, having participated in the exchange of experience. The IRZ is very thankful for this very trustful and fruitful cooperation. And Lars Brocker, President of the Constitutional Court and of the Higher Administrative Court of the German land Rhineland-Palatinate, is one of our expelled friends of Ukraine. De Lars would rather say the leading expert friend of Ukraine. Lars Brocker was not only part of the above-mentioned exchange of experience with Ukrainian administrative judges, the doors of his court at home in Koblenz are wide open for all Ukrainian delegations since years. And I think that there is no other court in Germany having had so many Ukrainian delegations as a guest. Dear Lars, thank you very much for attending also this conference. So coming to the end, we would rather be with you in Kiev now, maybe when the pandemic situation is over, when it's over, we all meet in Kiev again. I'm looking forward to that already now. All the best to you all. Stay healthy. And now I wish you fruitful, interesting discussion at this conference. Thank you very much for your attention.
Дуже дякую вам за ці слова.
Thank you very much for these words. We do hope that the justices of the Supreme Court who have not had yet chance to visit your land will have this opportunity to become familiar with the functioning of your High Administrative Court, the Constitutional Courts, the interaction with other authorities in your lands. Now I want to offer the floor to the President of National Academy of Legal Sciences of Ukraine, Doctor of Legal Sciences, Professor, member of Academy of Science of Ukraine. Thank you. Esteemed President of the Supreme Court, esteemed President of Cassation Court, of the Supreme Court colleagues, international experts. First of all, I'd like to say that it's a big honor for me, on behalf of our Academy of Legal Sciences, to greet participants of this important event. This very important event devoted to such a relevant and important subject matter. Our Academy has had very long history of cooperation with Supreme Court, in particular with the Administrative Chamber, within the framework of a number of different groups, including the Consultative Council. Now we have a tradition of annual summarizing events together with our national and international partners, with National Academy of Sciences, and we do it early July every year. Normally, the topics of these events covers the key matters. It's no surprise because the administrative courts are always on the edge of any matters of political and legal development of any country. In particular, when we talk about the protection of the basic rights of the people, namely the electoral rights. Today we'll review constitutional provisions on this area, the case law of European and national courts, and the European experience of protection of electoral rights. Now I'd like to wish all of
плідних результатів, які б сприяли
substantive and fruitful research in support of our mission, of the mission of Administrative Court, namely protection of electoral rights under the conditions of establishing the state which is based on the law. Thank you very much, Alexander. We always feel support of your colleagues. We are always happy to take part in the analysis that you implement with regard to the current legislation. We certainly hope for further interaction and cooperation with your academia and the scholars. Now we are finishing the welcoming remarks and we move forward to our first session, which is devoted to elections as a form of democracy, and we do rely on our speakers today. I'd like to say, first of all, that for each one of the speakers we'll have the time frame of up to 15 minutes. And we'll follow this format. First, we'll hear the presentations of all the speakers, and then we'll have discussions at the end of this session. Once again, let me remind you about your time frame. You have up to 15 minutes.
Constitutional right, electoral right, is guaranteed through elections, which guarantees free expression of will, and the laws and legislative acts guarantee their application. Fair elections allow citizens to make a real choice. Through such elections, expression of will of people happens as the only source of power and a sovereign. Everybody will agree that elections is a very important democratic process in the country, and it's the job of administrative courts. The Grand Chamber of the court has the job of protection electoral rights, but judicial practice is formed through changes in the electoral legislation as well. We can now conclude that in our country there is a trend to hold every new elections based on new legislation. Whether such instability of electoral legislation influences form of democracy, is it important to establish a certain time period when such changes could happen before elections? Now I give the floor to Mikhailo Smukovich. Title of presentation is Stability of Electoral Legislation as a Prerequisite for the Implementation of Human Rights and Freedoms. Please, the floor is yours. Thank you very much. Olena Kalashnikova, I welcome you all once again, dear colleagues, participants of the conference, ladies and gentlemen. Today's event will summarize the result of 2 years period of numerous elections in Ukraine. In 2019, we had elections of the president of Ukraine and parliamentary elections. In 2020, local elections, and in 2021, intermediate elections. This period is characterized by tense and successful work of administrative courts, including Cassation Administrative Court, a judicial chamber that is reviewing cases on electoral rights protection and referendum and protection of political rights of people in Ukraine. Reports of international organizations that observed the elections proved it. In the course of this period, administrative courts have reviewed about 9,000 administrative cases. Cassation Administrative Court, as first instance court, as appeal court, has reviewed more than 400 cases on electoral disputes of different legal nature, of different complexity. The main task of administrative court was protection of electoral rights of citizens of Ukraine, ensuring legitimacy and fairness, reliability of results that would be expression of real will of people. Cases of electoral dispute have certain peculiarities that complicate the work of judges. What are these peculiarities? Very short period for consideration, because electoral process is very swift and you can make quickly reasonable, well-founded decisions. But political aspect, this work is important. It is broad public interest and media coverage. Although our judges showed high level of professionalism and political unbiasedness, and we can confirm that administrative court judges and the justices of Cassation Administrative Court got through this trial with dignity. But still, I want to draw our attention to the fact that complicates our work. It does not depend on us, not on judges, not on courts, but on legislators. I mean, the problem of insufficient stability of electoral legislation. It quick changes and improper quality that prevents developing consistent legal practice. And finally, proper legal understanding and legal culture of all actors in electoral process, stability of legislation, and their clarity of understanding, logical consistency, and the perspective character according to official procedure and proper publication belong to formal components, also very important components of rule of law that are declared in Article 8 of Constitution of Ukraine and in Article 2 of the Code of Administrative Justice of Ukraine. Stability of legislation is one of the main conditions of realization of rights and freedoms of a person. Stability of the content of legal norms is necessary for the people to define the scope, procedure, and limits of limitation of rights and freedom. It has a special importance. It belongs to main international standards, in particular in the Code of Good Practice in Electoral Matters of the Venice Commission. a reference document of Council of Europe. In this document, among other things, writes that the main elements of electoral law, in particular electoral system, membership in electoral commission, and defining boundaries of electoral districts could not be defined later than 1 year before elections, because they're more significant than travel law. Stability of electoral legislation is very important to increase trust to electoral process, which is viable for strengthening democracy. Frequent changes of legislative norms can mislead participants of elections and causes special attention of judges. Problem of instability of legislation is not new. It is well known. I'm not going to analyze the reasons of that, but practically every elections in Ukraine are taking place, if not based on absolutely new legislation, but at least considerably amended legislation. Instability is such that often changes are made on the eve of election, several days before voting day. As regards electoral code adopted in December 2019, who in July 2020 was changed considerably regarding local elections, in particular regarding electoral systems, how to realize your voting right, how to nominate candidates, how to compose territorial election cassation, etc. These changes came into force on the 23rd of July 2020, less than 2 months before electoral process of local elections of 2020 took place. 5 days before formation of territorial election commissions composition started. Can we speak about stability of electoral legislation and about principle of legitimate expectations? Of course not. When assessing changes to legislation, researchers say that not always these changes are aimed at improvement of normative regulation of election. Some legislative acts in this sphere are approved by Верховна Rada on grounds of political expediency, not with the aim of improvement of regulation. Such unfounded changes of electoral procedures, in particular activity of electoral commission, and members of electoral commission themselves very often do not know about these changes. They are not professionals. That causes erroneous perception of activity of this composition, because certain provisions lost effect. Instability of legislation is a considerable drawback. It causes unstable legal environment and complicates a clear understanding of actions of all parties to election, and that causes instability of entire system of legislation and system of law. Instability of legislation causes violation of systemic connections, causing legal collisions, complicates implementation of principle rule of law, legitimacy, legal certainty, and complicates legal regulates and creates obstacles of legal culture and legal perception. In special literature, an idea is expressed to complement the concept of legal certainty, not to include unforeseeable changes in legislation. The requirement of stability of electoral legislation should not be interpreted as complete prohibition of making changes. European practice shows that making changes to electoral legislation is used quite broadly. However, according to data OECE, ODIHR, changes were made in Great Britain and in other countries many years before election. For instance, changes were taken in 2017. In Spain, the law of 1985 was changed only in 2016. In Germany, law of 1993 was changed only in 2017. In Estonia, the law of 2002 was changed in 2020. Our neighbors, Poland, electoral code of 2011 was changed only in 2020. What we see that changes are made, but they are made 10 years later or more. The Venice Commission adopted a special declaration on stability of electoral legislation that once again explained that less than 1 year before election, you cannot change such fundamental provisions like electoral system, formation of electoral commission, and change the boundaries of electoral district. Other provisions could be reviewed even later if these changes are aimed at implementation of European electoral standards. But that is done at sufficient time before election. So principle of stability formulated by the Venice Commission does not exclude development of electoral legislation on the way of improvement of provisions, maximum implementation of European electoral standards, or even profound reform. But requirement of stability means reasonable time when such changes are made long before election. Stability of three concrete object of regulation: electoral system, formation of electoral commission, and establishing boundaries of electoral district is founded by the fact that these factors impact results of elections mostly. And changes of these provisions at the last moment can cause manipulation, or at least provoke understanding or manipulation of interest of ruling party. The Venice Commission says, although electoral legislation is not carved in stone, it should not be changed all the time, because change of the rule of holding elections directly before election, especially during election process, does not facilitate democratic nature of elections. As you see, changes made in electoral code in 2020 were not in compliance with international standards of stability, because it touched all the three basic components defined of the Venice Commission. Such practice cannot be approved. We believe it is necessary to support the position expressed in the literature about stability of electoral law. Permanent approach to regulation of societal elections, abiding by major principles of relevant branch of law, and possibility of systemic evolutionary changes of legislation, removing some drawbacks that are shown in practice or in judicial practice. Such stability is needed for electoral legislation of Ukraine today. What ways to achieve stability can we define? First, establishing prohibition to make changes in important norms defined by the Venice Commission 1 year before election, and other changes not later than half a year before election. That gives enough time to get to know all this novelty by all potential participants of election, and could allow proper preparation and the publication of all necessary bylaws by Central Election Commission, and training could be conducted. Training for judges on novelties of legislation could be conducted. All changes made in electoral legislation should be agreed with the main principle of electoral law included in Article 71 of Constitution of Ukraine. Don't allow a narrowing the content of existing electoral rights according to Article 23 of Constitution of Ukraine. And finally, taking into account lengthy process of constitutional reform, one should include basic elements of legislation electoral systems for particular elections at the level of constitution that will ensure their stability and limit endless experiments in this sphere, depending on the desires of ruling political parties, a proportional, or majoritarian, or mixed, etc. Judges of administrative courts who are authorized to consider such cases are always preparing for the challenges of election. Seminars, roundtables, other discussions are organized to discuss novelties in legislation, for exchange of experience, how to resolve electoral disputes. An important role is played by this international conference. However, compliance with the requirement of stability of electoral legislation by legislators will facilitate proper work of judges of administrative court, development of consistent legal practice, and that will bring us to effective protection of electoral rights, strengthening democracy, and establishing rule of law country. Thank you for your attention. I fit into time limitations, and thank you very much. Dear Mikhailo Ivanovich, we are thankful to you very much for such interesting presentation. As we understood you correctly, your analysis brings us to the conclusion that stability of legislation as an element of rule of law is the factor that will enhance trust to electoral process as basis of democracy. Thank you very much. In continuation of this topic, I invite President of Association of European Administrative Judges, Judge of Administrative Court of Vienna, in Austria, Edith Zellen, European experience and practice of the European Court of Human Rights in resolving electoral disputes. Please.
Thank you very much. Honorable Madam, Honorable Sir, and dear colleagues, I'm also happy to participate today in the conference, and I would like to thank the hosts for inviting me to participate today. I can only echo what I have heard from the distinct speakers in the welcome speeches about the relevance of elections, as elections are the core of democratic process, and thus they are the fundamental rule of law. And I can only echo as well and repeat, because of the relevance of it, that therefore judicial review is absolutely important. Independence of courts which receive the full trust of society is of utmost importance, specifically also with election processes. This is even more and more relevant as in recent years, practice we have seen, and we've heard different cases that political actors try to influence courts in order to win the elections or to stay in power. And even the more, it is very important that the public perception around elections guarantee confidence in an independent judicial review. So it's a very broad topic, and so much can be said. I can only somehow assemble some puzzle pieces in the whole puzzle game. And I would like to contribute with some practical remarks from European experiences. Also, I repeat what the former speakers have said, that it's a very special area. There are certain specificities of electoral protection of electoral rights, because it's quite broad. Involves different phases, pre-election, election phase, and after election, as well as it involves different actors like candidates, like voters, many other participating management electoral bodies. So this makes it also quite special. And I can only refer to specifically from the Venice Commission, the Code of Electoral Practice of 2002, as well as the report on election dispute resolution. This forms, together with the jurisprudence of the court in Strasbourg, the excellent basis for the best European practices. Coming to the dispute mechanisms, in election cases, there exists no uniform recommendation, and there also exists no uniform practice in Europe. We find remedies to annul, to modify, or to recognize irregular acts. And in addition, we find also other procedures in order to determine administrative or criminal responsibilities. Also, there exist different ways to annul elections. What President Smokovic has stressed is clear laws and clear competences of the control organs, and not subsequent frequency to change the law. So this is very important, and has also been stressed by the Venice Commission. So simple procedures are also relevant, and their formalism should be avoided. These are also some general remarks for any process on judicial review of election procedures, which are relevant for all European countries or international wide. Briefly, what are the grounds for complaint? In principle, any breach of electoral law can also affect electoral rights. It is clearly recommended that also inaction or inadequate enforcement should be included to be grounds for complaints. Because this can also de facto impede electoral process. Who may complain? Another relevant issue in this respect is who may complain. This is also regulated in different ways in our European countries, because it must be also differentiated between the subject of electoral complaint. For instance, who is eligible to complain, for instance, against the election result, or against the voting list, or against the candidate registration. This depends very much on in which process, in which stage of the election we are, and which subjects are involved. However, in general, most European countries provide rights to lodge electoral complaints to at least both to the voters and to the candidates. Next question, which is relevant in many judicial review proceedings, is who decides on the complaint. Also here we have diversity in European practice because there exist different models. This depends again on national legal history very much. We have in some countries ordinary courts which are competent to decide on electoral disputes. We have sometimes special courts or constitutional courts or electoral commissions. Sometimes in some countries, Scandinavian countries, or Belgium, for instance, you have an appeal to the parliament. So the parliament, the judge of its own election is the parliament. This is definitely not European best practice. And in this respect, I want to refer to a very recent Grand Chamber judgment of the court in Strasbourg, Munge Mangango. So it's okay to have the parliament involved. However, judicial review to a court after the parliament has decided is recommended, should be the case. This was also recommended by the Venice Commission as well. However, in general, to have a judicial review at the end is definitely also recommended and underlined by the court in Strasbourg in its broad jurisprudence on this Article 3 Additional Protocol 1. For sure, in several European countries, we have the Supreme Courts, which decide in election cases, like for instance in Estonia, Poland, or Serbia. In some countries, like Hungary, you have even a two-instance judicial control. In many European countries, we have the constitutional courts, which are competent to decide electoral disputes, like for instance Austria. And I come back to Austria a bit later in the end. Here the Constitutional Court validates not only parliamentary elections, but also other democratic elections like referendums or elections of the president of the federal state, also local elections of the local authorities, and also from professional entities like, bar association or something like this. So it's one central organ, the Constitutional Court. This system exists not only in Austria, but in many other countries. We have some distinct speakers from other European countries today present who will explain their model in more detail. In France, the civil judge is competent to control the establishment of electoral lists, whereas administrative courts first instance are reviewing the local elections, like municipal elections or departmental elections, with a judicial appeal possible to the Council of State. The Council of State in France, the Supreme Administrative Court, so to say, the Council of State reviews directly the regional and the European elections. And the Constitutional Council in France reviews directly the presidential elections as well as legislative elections. In Spain, the final decision is taken also by the Constitutional Court with respect to breaches of fundamental rights after the Administrative Court has decided. In Portugal, it's as well the Constitutional Court, and also constitutional courts are competent judicial review organs in Bulgaria, Croatia, Slovak Republic, or Romania, for instance. Administrative courts are specifically engaged in Luxembourg, and we have specific electoral courts in Greece and in Sweden, for instance. And I've briefly mentioned before that also parliaments take a certain role, have a certain role, for instance, in Belgium, Denmark, Norway, in this respect. So it's very diverse, and there is no uniform best practice or no recommendation on this respect. What is relevant in general is that appeal proceedings should be as brief as possible. And this is a certain specificity because you need to balance effective judicial protection and versus quite quick, smooth and continuous electoral process. So this is not always easy. Two pitfalls should be avoided in this respect, namely that appeal proceedings retard the electoral process, as well as that there is no suspensive effect and the decision would come too late. This brings me to the next question: within which time period? This is a very specific problematic question, stressed also by the court in Strasbourg. For instance, in an Azerbaijan case, Aliyev versus Azerbaijan, the tension between a fair process and a fast process. But the short time limits may not undermine the effectiveness and to guarantee fair trial standards, so to say, although we do not have Article 6 of the Convention applicable. In practice, it's always a challenge. In practice, some issues come up concerning who has the burden of proof and access to evidence, because who brings in the lawsuit must bring some evidence, and often it is complicated to bring sufficient evidence to have access to evidence, specifically with respect to short time limits. So this is really an issue in order to guarantee an effective judicial protection and an effective review. Let me finalize, and I'm still in the time limit, I hope, yes. Let me finalize with a remark, an Austrian landmark decision, so to say, for the Austrian concerning Austria. It was a landmark decision of the Constitutional Court in 2016, because here the Constitutional Court quashed the federal elections for the federal president of the Republic of Austria, and the elections had to be repeated. A re-election was ordered because, and relevant here is the issue of postal ballots, because the Constitutional Court has stated that there was an unlawful evaluation of postal ballots, as well as that was a violation of the principle of freedom of elections. Briefly, the facts: we had two candidates, one of them needed to gain more than 50% of the votes. The determination of postal ballots is concentrated and in the competence of collegial organs, namely the local electoral authorities, being collegial organs. And we have the jurisprudence, and it's clear that you need to have utmost transparency and very strict and very clear procedural rules, which are also strictly interpreted in order to guarantee that the democratic process of electoral counting is correct. Therefore, it is regulated that this collegial organ, this electoral committee, may be supported by auxiliary personnel, but they may only support them with respect to only when all the members of these collegial organs see them, and so that they can control that everything is okay. In our case, the postal ballots were in an envelope, and these envelopes were simply opened in order to accelerate the counting process afterwards. They were opened by the auxiliary personnel, by the person supporting the electoral committee, only under the eyes of the chairperson of this committee and not under the eyes of the whole all members of this committee. This was seen to be a problem with a strict interpretation. In addition, what has also happened is what has been practiced in Austria since the 1970s is that already before all local electoral committees have done the counting, after the end, some trends were communicated to the media, and some raw data were communicated to the media, as well as some agencies which would make some forecasts. This has been, it was not violent, it was not prohibited by law, and this has been practiced. And in this case, now in our case, the Constitutional Court recalled that an alleged illegality of an election must be proven. And it must have been of influence. So far, it has been constant jurisprudence of the Constitutional Court that it, namely the Constitutional Court, has discretion in the decision if such illegality was relevant and would have been of influence, so that the Constitutional Court had discretionary power to decide, well, there was an influence, but would this influence have been relevant? Now, in this case, in this landmark decision, the court said, no, it's sufficient that you have the theoretical possibility of these postal ballots now here, and the number of postal ballots, in case, in theory, they would have been influenced, and it would have been for the other candidate, it would have been, by counting the numbers, could have been theoretically spoken of relevance. So this was quite new, because it said, well, the theoretical possibility is sufficient. In addition, the court referred for the first time to the principle of freedom of formation of political will, as well as the principle of purity of elections, because the court said, well, yes, we know about this practice to give some raw data to the media and to some trend companies, or companies which would show some trends. But this, in nowadays time, this cannot be controlled anymore. When you provide information to somebody, it's possible, it's more likely to be leaked than in former times, because of social media, because of easy ways to transmit information, easier than was 20 years ago, for instance. And because of this change of society, change of the world, so to say, it can no longer be excluded that there could be a theoretical influence of those voters who have not yet voted. Therefore, it has formulated for the first time this protection of the will of the voters. And all in all, the federal elections of the state, of the president of Austrian state, had to be repeated. The next elections brought the same results for the candidate who is now president of the Austrian Republic, Mr. van der Bellen. And the chairpersons of those electoral committees have later on been criminally convicted, because it would have been their obligation to make sure that this auxiliary personnel supports the committee under the eyes of the whole of all members of the committee. This was quite new for Austria, and so far it was well decided, and that's we had no further relevant judgment so far since 2016. Thank you very much.
Дуже дякуємо вам. Дуже дякуємо вам.
Thank you very much for your very practical comments in connection with the European Court judgments, for making us familiar with the European experience with respect to electoral dispute resolution through other than judicial authorities. Also, let me pass you greetings from our Ukrainian judges colleagues, judges, women who have personal, very friendly relationship with you. They asked me to say hello on their behalf to you. And now we are moving forward according to our plan. And now I'd like to offer the floor to the Assistant Professor of Theoretical Legal Science, National University Kyiv-Mogila Academy, member of Scientific Consultative Council at the Supreme Court, Doctor of Legal Science, Mr. Yuri Krishkovsky. He will talk about the Electoral Code, the brilliance and poverty of codification. The floor is
Esteemed Madam Moderator, dear ladies and gentlemen, thank you for this opportunity to express my thoughts to such high-level meeting. The topic of the first session is linked with the substantive law that includes many important problems, but focus attention at one aspect. First, assessment of experience of codification of our legislation. Electoral Code of Ukraine was adopted quite unexpectedly on St. Nicholas Day in December 2019, and then St. Nicholas's gift was accepted positively by expert community and international organization. They welcomed Ukraine. Both Council of Europe and the Venice Commission welcomed Ukraine. Adoption of Electoral Code is a very positive step on the way of reforming national electoral legislation. Generally speaking, I don't see my presentation on the screen. Codification of electoral legislation is quite a general trend in Europe, in this and that format. Either legislative acts, which are codes, or sometimes not codes, they exist in many European. Second slide, please. When adopted, please show slide number 2. When adopting this electoral code, Ukraine stood at the same level with European countries. And that shows that this is a step in proper direction. But more than a year passed since that time, and we can make first assessment, assess the consequences, especially take into account that it was applied first time in real battle, so to say, during local elections last year. In order to assess how codification of Ukrainian legislation took place, we should look at the main objectives set when codification happens in any legal sphere, in electoral sphere in particular. First of all, you can see whether systemic approach and consistency is applied on the basis of uniform system of principles in such a way that they are common for all elections, for nationwide elections and for local elections. Mainly, electoral code fulfill this task. Chapter 2 is devoted to that, not only 5 classical principles embodied in Constitution, but the principles that were not included in our legislative documents before, but were in international standards. Second basic objective of codification was to achieve unification of legal regulation of similar electoral procedures for different electors. This is the major problem of our system, because elections of different levels were regulated by different laws, and that caused unnecessary differences. The code was supposed to resolve this problem. What were other objectives? Overcoming multiple number of electoral laws to avoid their intersection and to ensure complete legal regulation of elections by uniform codified act. If we set such a task to codify, it's a major task. The code must ensure legal certainty and to meet legitimate expectations of all the actors, because they are the components of rule of law, and they should be abided by. Other important purposes of codification to achieve compliance with related legislation, whether law on citizenship, for instance. Even judicial practice showed that there are certain problems there. Law on political parties, law on mass media, and numerous other laws, creating conditions for raising level of stability of electoral legislation. Previous speaker mentioned that there is such a doctrinal idea that a code should be quite a stable act, but in practice it's not implemented in Ukraine somehow. But in the codified act, all changes should be mutually agreed and should not violate codification and regulation of procedures. And last but not least, to ensure sufficient convenience of the use of the code and clarity of its structure. All that is important for all actors of electoral process, but I want to emphasize why they're especially important for the courts. To use substantive law, which is not in proper state, that required additional interpretation or filling in the gaps and collision that complicates the work of the judges. Summing up, I must say that electoral code should be a consolidated text, should be based on the uniform system of sectoral principles of law, be internally agreed and logically structured to ensure completeness of regulation and not cause collisions. Legislature, when realizing codification, took huge efforts to achieve such goals. However, in order to assess adequately success of this act, you must assess to what extent these goals were achieved and which problems arose after codification. First of all, one should pay attention to the fact that codification is incomplete. What was not regulated in this code? 2 important electoral laws on Central Election Commission, on the state voters register. Existence of other legislative acts alongside with the code creates special problem. Correlation between provisions of the code and the special laws. You know, when there are collisions between 2 acts, preference is given to a special law. And since the code is always a more general law, so it gets the preferential action. Then the law on central election condition or on voters. And the judicial case law showed that. It was found that position of Grand Chamber of Supreme Court regarding powers of Central Election Commission give advantage to the law of Central Election Commission. And Cassation Administrative Court believed that Electoral Code was the major act. Such differences in position were caused by incompleteness of codification. I want to quote what French expert Carillac mentioned. Every code includes the desire to make it exhaustive in its sphere. Unfortunately, our code has not achieved that. Similar problems in the law on the state register voters. That pertains mainly to problems of electoral address and the right to vote at local elections. According to Article 141 of Constitution of Ukraine, right to vote at local elections have resident particular village, town, territorial community, but it's not written concretely. Actual residence or official registration is taken into account, and discussions are possible here how to resolve it. But the law on the state register provides a free declared possibility to change electoral address to any community without any proof of residing there. So a voter assigned to a community on the basis of electoral address. These two norms are well agreed. And we can hardly say that Article 141 of Constitution is abided by. These problems were found during local elections in 2020. Another important issue that arises when codified a particular legislation is huge scope of legislation. Electoral Code requires a structure of appendix, a general part where certain common norms for all elections are included, and a special part when there are norms that are specific for a particular type of elections. Regrettably enough, in the code adopted, the content of the general part is narrowed, not because certain laws were included from codification. A number of norms necessary to be codified were not codified. Compared with the draft law, which was submitted initially, the scope of general part was reduced 3 or 4 times, not only by size of text, but objects of regulation were reduced. So many similar provisions are repeated in different parts, very often with unfounded arguments. What's important for local elections, institutional structure, not appendix type. Different norms regarding different types of local elections are put together, and they complicate perception of material, and it's difficult to understand it. Instead of separated by different type of election in special part of the code. So examples, when norms are repeated, status of power of official observers, mentioned 4 times in different norms. Early termination of powers of Electoral Commission, 3 times in different norms with different changes. Procedure for voting at the place of stay of the voter. It must be uniform. It's written in 3 articles differently. Procedure for counting votes, at least its major part, regarding which so many conflicts arise, not only at local elections, but intermediate elections, differences which are not founded at all, that does not allow us to achieve unification of similar norms. Unfortunately, the text of the code includes a number of gaps and internal collisions. For instance, Article 65 in the part regarding complaining against violations does not provide for the possibility for polling station commissions to consider complaints. It brought us to a situation that at semi-official site, Connected Central Election Commission aimed at training on members of PECs. They gave recommendation, do not consider any complaints, bring them back to the applicant. It's not provided to the proper agency. So, polling station commissions cannot review complaints connected with voters. I previously mentioned 3 articles where this provision is given to polling station commission. Moreover, the articles that regulate concluding meeting of the polling station commission members, in this regulation is written that number 1 on the agenda should be reviewing complaints submitted to PEC. Only if they do it, then they can make conclusions whether they recognize the results of voting at this polling station. So the gap in Article 65 is a very serious violation of principle of legal certainty and creates a collision that should be taken into account and then interpreted. Number of other sad examples. Lack of attention from legislation. Article 67, possibility a representative of candidate in territorial election commission can file a complaint at local election. Article 238 doesn't provide existence of such a representative candidate. He can file a complaint, but he doesn't exist. Article 237 at local elections allows certain benefits for candidates who run for deputy's position. They cannot be dismissed during the campaigning period when they run for elections, etc. These guarantees are needed to ensure freedom of campaigning for such candidates, but for candidates to the position of head of territorial community, such guarantees for some reason are not provided. I must say that despite the fact that these elections that are not held anymore are mentioned many times, the other outcrying mistake, appointing repeat voting. It includes grounds for repeat voting in multi-mandate majoritarian district or territorial community containing more than 100,000 residents. That doesn't meet the requirements of previous article in the code. So direct collision between 2 norms in the code. And I'm afraid when these issues will be resolved in case of dispute, I don't know how it will be resolved. During previous elections, such conflict didn't happen, but still, you should pay more attention to contextual interpretation. What is written in 269, I think it's erroneous, but still it is in the law. Textual drawbacks. Honestly speaking, I have never seen a normative act with such low level of preparation of text. Same norms are repeated several times. Article 25, 2 parts have same absolutely similar text. And there are dozens of examples like that. Part 6 of Article 63 reflects what is written in Article 24 regarding the work of state authorities, including courts, on election day. What for? This norm is repeated 2 times in 2 different articles. It's difficult to say. So behind the outer glamour of the codification, and in general, codification should be perceived as a positive phenomenon, we see quite low quality of normative text. I gave only few examples, extreme examples of such drawbacks of normative text. I mentioned only the problems that I connected with legislative technique of codification. I didn't touch the substantial problems. It must be the subject of separate analysis. Some provisions are now under consideration of Constitutional Court. But I would like to draw your attention to the fact that all these difficulties complicate the work of all actors of election process during any elections that we had, and create additional problems for legal application, especially in the courts. I must draw attention to the judges that the problems exist, and one should approach their resolution with great attention. We want that legislator also pay attention to this. Such technological questions don't have political context. They should be corrected easily by legislators who want to have a quality text of the code. Now a working group in the relevant committee of parliament is working on that. Contra spera, I still hope that such remarks would be taken into account and they will pay attention to these problems and to remove them as soon as possible. Thank you for your attention. Thank you very much. So we could hear that due to the fact that Верховна Rada adopted this electoral code, Ukraine raised to the same level with European countries. Although still there are many drawbacks in election legislation. If there are any questions, I can answer them. First, we agreed that first there will be presentation and then will be time for comments, questions and answers in the end. So I ask all participants to wait until the end and then you will get answers to your questions. You can take part in discussion. Thank you very much. We are changing this sequence. Now the floor is given to lawyer at the Registry of European Court of Human Rights, whose practical experience is very important. He will tell us about the case law of European Court of Human Rights on issues related to political parties formation, activities and restrictions on the activities in election and intra-election period. Mr. Dmitro Tretьяков, please, the floor is yours. So please, the floor is yours.
Пане Дмитро, увімкніть, будь ласка, мікрофон.
Please put your mic on. I'm sorry. Okay, so once again, good morning. Today I'd like to concentrate on a more specific matter rather than doing an overview. It's about activity of political parties because actually there are many guarantees of freedoms and rights. Namely, with regard to electoral process, there are some rights emphasized in the judgments of European Court, other international documents, let's say. The deed on civil and political rights, in particular Article 29 guaranteeing the right of free election. The Commission clearly stated that the citizens are participating in the governance through dialogue with their representatives or actually by self-organization. And this is what the Convention guarantees, that's freedom of assemblies. Also, OSCE documents have been mentioned today. With regard to elections, they stated that the state respects the rights of individuals to create their own political parties or other political organizations and grants the required legal guarantees to such political parties or organizations, allowing them for running and participating in the elections. I will talk in the context of elections, but I'd like to note that there are some points worth to be mentioned with regard to freedom of associations. There are some nuances where it depends on whether that's a political party or an NGO. And here the matter of elections becomes specifically important. Artyom versus Russia. Artyom intended to register their political party, the Russian Public Union, and their request was refused because of the word Russian, because they belong to an ethnic group, and political party, in contrast to NGO, is not supposed to have any references to ethnic origins. So they were not registered, and actually the European Court denied their application in view of the fact that they could continue their activities as an organization, and the refusal to register them was justified. It was not the restriction on freedom of assembly. That was restriction on the status of this association and the ability to offer candidates for elections. Had they been registered as a political party, they could have run the elections. And the European Court, upon review of this matter in the context of creation of political parties, considering the restrictions existing in Russia, stated that that was not any violation. What I'd like to note, we are talking here about the electoral rights, but some rights refer to actually voters, but some to those who run, who candidate. In particular, there was a case, Georgia Labour Party versus Georgia. It was stated that the lists of voters and polling sections existed, and the question was how independent the Electoral Commission was. But the court stated that in that case, in spite of any criticism that can be used, the party could not prove that its rights had been violated anyhow as a party. In contrast to that, if an individual files an application stating that his or her party was removed from electoral process, that would not mean that his or her party, that his or her rights were violated because this individual can vote for any other party. It's important to keep in mind that any electoral blocks sometimes create political parties. Then sometimes when request for registration of such party is refused, may later on influence over specific candidates. We had the case of Batasuna versus Spain, where two political parties were dismissed. Initially, they had a coalition, then they became a party, and then they were dismissed because they had connections with terrorist organizations and tried to justify terror activities in order to achieve their political goals. So the court didn't find any violation, and but then what happened that some individuals from that parties tried to run for elections at a regional election. It was the case Siberia, Bredaxa, and others against Spain, and the European Court in that case stated that in fact they intended to continue same rhetoric, same narrative that was initiated by this political parties. So their removal from the register was well justified because of the same reasons that in the previous case with the political party. In addition, the European Court didn't find any violation in the recent case Chernega versus Romania, where the party members not represented in the parliament were prohibited from running for local interim elections, and the court stated that the question was just about one seat, the restriction was not that serious, and the state had a sufficient margin of discretion to deliver such decision, to make such decision. Talking about participation of a party in the election, what other restriction may exist? That may be threshold, like in Turkey, it's too high. 10% in other countries is too low. And the European Court held that many countries, for different purposes, make these thresholds either too high or too low. On one hand, maybe to ensure the maximal representation of as many parties as possible, and in other cases, due to some historical, cultural conditions, they try to limit the number of parties in the parliament. So the Turkey, the electoral threshold is criticized as too high. It was a specific case. A decision was delivered by the Grand Chamber. In general, the court held that it can be permitted in view of political peculiarities of the country. I mentioned this case of Russian Conservative Party versus Russia. The party was removed from electoral process because some of their members made false statements for registration purposes, specifically with regard to their financial status. In fact, what could be done, the party could easily replace them with other candidates, and then the party should not have been removed, so the court found a violation. On the other hand, disqualification of another party, it was in Netherlands, it was justified by the courts because it was traditional Protestant party, and they believe they should not participate in the political life. They were offered to be included into political lists. They refused. So they were removed from the registration for re-election. The European Court didn't find any violation of Protocol 1 or Article 14. In addition, sometimes there are questions about removal of a party from elections because of improper funding. But here again, very powerful proof is needed, and any allegations of this kind should not be based on just guesses or assumptions. So last year we admitted, we delivered a case in the case of a Moldovan party, where the members of this party included a businessman who was the chairperson of this party, who has business in the Russian Federation. And the public authorities decided that the political party is funded through his non-registered contributions, and the party was removed from elections. But since these were just assumptions and no formal evidence had ever been submitted, the court found violation of the rights of this party. Talking about more serious interference with the partisan activity, that's Article 11 of the Convention about the freedom of assembly, where the party, or associations, I'm sorry, where the party is dismissed. The question is whether such actions were justified. We had a number of cases against Turkey. 4 of them were about the party, where the leaders in their political programs included matters of Kurds, protection of their rights, equality of their rights, which certainly provoked a reaction from the Turkish public authorities. These parties were prohibited. That was the United Communist Party, Socialist Party, the Party for Freedom and Democracy, and the Party of People and Labor of Turkey. And the court stated that even if a certain political force suggests a different organization of the state or a different political development without suggesting implementing it with unlawful means, the party cannot be removed from elections. On the other hand, in the case the party Remark versus Turkey, it was one of the major and popular political party who had very good odds to win the elections. The registration was cancelled, and the reason was that they suggest that introducing Sharia laws in the country, Muslim Sharia laws, and the leaders clearly stated that they intend to move away from democratic regime, and actually they were removed from the registration, and the court didn't find any violation. I am almost running out of my time. Talking about the rights to vote, in these cases, the rights, electoral rights, there were complaints concerning the violation of the right to participate in the elections to the parliament, where the court found violation. They stated that there was no need for separate judicial review. They were just additional applications. There was no need for any additional consideration of them. Thank you for your attention. If any questions appear by the end of the session, I will be happy to answer them. Well, it's really difficult to overestimate your experience and the Thank you very much for this candid sharing of your knowledge and experience with us. We are moving forward to the next speaker. It's about case law of European Court through the freedom of expression. And we have here the manager of the Council of Europe project, Ms. Irina Kushner, candidate of the legal science.
Дуже дякую за запрошення, особливо виступити.
Thank you very much for the invitation to take part in such in-team group of speakers. Please show my presentation on the screen.
Дякую.
Thank you.
Оскільки часу
Since time is not enough to cover such huge topic of freedom of expression, especially during the election process, before and after election, I have only 15 minutes. Therefore, I decided to focus attention on main case law of European Court regarding standards of freedom and the role of this institution in electoral process. Slide number 2, documents of Council of Europe. You see a list of founding documents pertaining to electoral process, freedom of expression. First, recommendation of Committee of Ministers of Council of Europe regarding coverage of elections by mass media. One of the most significant documents includes many principles, many references to case law, European Court. Code of Good Practice in Electoral Matters of the Venice Commission. It was mentioned today already. It's also a useful source of law for freedom of expression in election process. And last but not least, Convention on access to official documents. This is quite a new international act of Council of Europe, recently ratified for Ukraine and became effective. A very important document defining access to official documents, or maybe talking using national terminology on access to public information. Next slide, judgment of European Court. Short list of cases where you can find broad jurisprudence of European Court as regards standards of freedom of expression and their specificity, the peculiarities of freedom of expression in electoral process. This list is not complete, not exhaustive, but I think the judgments shown here on the slide are defining, and I shall mention others later. General foundations for freedom of expression. I could not avoid from not mentioning what is written in the Convention, and European Court reviewing cases referred to them, but with some peculiar. Freedom of expression is one of the most important foundations of democratic society. You can find these friends in different documents. However, when talking about this institution in electoral process, we must remember that these are mutually connected, mutually dependent things. Two fundamental laws, Article 10 and Article 3 of Protocol 1 to Convention. Mutual relation means that free, well-informed, aware elections are not possible without objective information. Therefore, during electoral process, this right to free expression of thoughts, during, say, parliamentary elections, is enhancing public necessity, public significance of the information, provided by mass media, bloggers, by whoever. On the other hand, freedom of expression is quite a specific instrument that could provide information objectively, provide free, informed expression of opinion of people, and to distort perception of society of what is really happening, depending how information is presented. In this connection, case law of European Court shows in many judgments, the court agrees that the state may and must limit freedom of expression to ensure conscientious, free expression of will of society. In European countries, serious discussions are going on. To what extent the state can limit freedom of expression of thoughts for the sake of preservation of this conscientious right of choice, of right of information. And then a specific notion appears, disinformation. Disinformation, not only untruthful coverage of the fact, but distortion of the facts. Demagogy, in the sense of freedom of expression of thoughts that distorts pluralism thoughts and threatens free expression of will during elections. We have one of the first cases on this problem. It is now under consideration of Grand Chamber of European Court. Final judgment is not made yet. Let's move further. Article 10 can be applied not only to information or ideas perceived and understood as not insulting, but those that can insult, can trouble. To what extent you can shock, insult society during election process? It's an absolute standard of freedom of expression, but it doesn't mean that a speaker during debates can allow himself or herself whatever he or she is willing. It must not exceed the limits that mean excessive insults that do not contain factual basis. There is a case, Vitrenko versus Ukraine, not less known, Institute of Economic Reform versus Ukraine. Two opposite cases regarding judgmental cases. Vitrenko versus Ukraine is known. Ukraine didn't violate Article 10 because the then famous politician Natalia Vitrenko, during campaigning debate with Yulia Tymoshenko, other well-known politician, allowed herself to call Tymoshenko a thefter. And that was the basis. To what extent the thefter is perceived by society, what kind of impression it produces, whether it is judgmental idea or it's a fact. And European Court agreed that objective realities in cultural environment in our Ukrainian society, this term makes the impression that a person have made particular actions that could be specified as fraud or theft. And for that, Vitrenko should have provided factual evidence. This evidence was not provided. And after debates, Vitrenko was taken to responsibility for what she said. That was kind of interference in freedom of expression because it was excessive freedom of expression, and the court ruled that Ukraine didn't violate Article 10. Other cases, expressions pronounced during election process by a journalist. A journalist allowed himself to talk about a famous politician, Hannah Herman, from the point of view of her engagement, her biasness, her professionals in demagogy. She could convince people that the power that she is affiliated to, the power of ex-President Yanukovych, was the best that could exist in Ukrainian society. Accordingly, the journalist allowed himself such expressions as for such high remuneration one can wear, hinting that she, Madam Herman, former journalist, has sold herself to the authorities, was cooperating with political parties using her talent and skills of speaker and journalist, did it for getting remuneration. She received an apartment in Kyiv. A journalist complained to European Court that the expressions that he was taken to responsibility in Kyiv were unfounded. And he wrote in his article, not every Ghana will get a free apartment in Kyiv. And he alleged that these were judgmental expressions and which evidential base was possible. And as distinct from the previous case, European Court agreed with the arguments of the claimant and ruled that Ukraine violated Article 10. Journalists, watchdogs of society, the whole concept of the key role of journalists in freedom of expression, in transferring information, informing society about phenomena that are taking place. And their role could not be overestimated during election process. But still, I want to warn you that there are certain standards for freedom of expression. If you look at recent judgments of European Court on freedom of expression regarding access to public information, there we can see a certain vague approach to institution of journalists. Journalists' concept is not so stable. A blogger, small publication that based on national legislation doesn't have the status of mass media and their staff are not journalists. Civil society organizations could be believed the watchdogs of society because well-developed internet gives opportunity to every individual, especially if this is a civil society organization. Every person can say that we are playing the role of watchdogs of democracy. A couple words about general foundation. You see, the quotation of European Court, there is almost no possibility for limitation of freedom of expression when one means speeches of politicians or questions of public interest. Of course, question of politicians, candidates for positions during election, about their past, about their assets, even about their relatives, is publicly significant information. It is of public interest. There is almost no possibility of limitation. But when talking about electoral process and remembering that dissemination of information not only impacts perception of society, but impacts their choice during electoral process, European Court starts taking a careful approach to non-existence of possibility for political debate. The first case on disinformation, NIT is against Moldova, pertains to revision or development of this concept in connection with electoral process. In this case, the claimant is a private TV radio company which, after previous warnings about violation of legislation, the government revoked its license for broadcasting. The authorities accused them absence of pluralism, distortion of information, not unreliable information, but just distortion of information. and permanent trend to criticize authority by this TV chairman, at the same time praising very much other political party, which was in opposition. We can compare our current day events with the circumstances of this case. Private TV radio companies criticizing authority all the time is distorting information, combining it with the trend of praising actions of one political party in opposition all the time. I mentioned this case as the first signal, first case in European countries that some limitation of freedom of expression is possible when it is necessary for preservation of free, conscientious expression of will. Another case, which is fundamental for consideration of freedom of expression in electoral process, Animal Defenders International against United Kingdom. It is translated differently into Ukrainian, but it's against UK. What was the question? According to UK legislation, any political advertisement, paid advertising on particular TV channels, and the most powerful, highest rating TV channel was selected, political advertising was banned at all, not only for political actors, for political parties during electoral process, but for other persons, for civil society organizations, who by their nature had some political area of work. Our organization asserted that we are not politicians, we protect animals' life. We take part in political life, we review programs of politicians, they have their own programs regarding legislation, how it should look like as regards protecting animals' rights. And they asserted that that general prohibition causes unproportional limitation of freedom of speech. They made a video that, according to government criteria, belonged to political advertising. It was aimed at protecting the rights of animals, primates. Accordingly, it pertained to legislation, and they called to change legislation in connection with pre-election campaigning promises of politicians who were running. This video was banned. European Court started considering this case, looking whether such blanket prohibition without possibility of any exception is possible without court consideration. First question that was raised, a key question that was procedure of adopting this legislation. In discussion, opinions that were expressed by national authorities, by civil society organizations that demonstrated degree of respect, degree of interest, degree of engagement of state officials to this problem, freedom of expression, and its prohibition. After reviewing this case, European Court agreed that at that time, when this legislation was adopted, very broad debate were taking place. All engaged authorities, all stakeholders, including civil society organizations, engaged professionals, expressed their thoughts, their arguments, discussions were going on, and that provided the impression that it's not just a blanket prohibition, but a reasonable prohibition with respect to free expression, freedom of expression, and free choice during election. It was a reasonable attitude in the state. Second issue discussed by the court, prohibition of political advertising only at certain TV channels who are very powerful, who had great influence on perception of society. Other platforms remain accessible. Internet printed media, other platforms where freedom of expression could be manifested differently, other than political advertising. Interested persons could have given interview, could have taken part in television talk shows and present their ideas. What else was noticeable for European Court? Even those TV channels were allowed certain quotas for political advertising for free, but quotas were clearly regulated. Which political party, not only which political party, which persons were authorized to broadcast their political advertising from the point of view of their engagement in political process. If political party was an actor in election process, certain quota were provided. Next slide. Facts and judgments. What Article 10 doesn't defend? Values, election. Electoral process cannot justify freedom of expression used to ruin the values that are defended by convention. You can see case against Netherlands where claimant complained against dissemination of some leaflets regarding discrimination. They are prohibited method. And the question was not whether Article 10 was applied or not. It didn't pertain to these issues. No protection was granted. Forms of expression of opinions. Here on the screen, you can see versatility, different forms. Agitation or provision of information, certain platform, internet platform, TV channel that invites other persons that could express their opinion, but it is a platform for expression of freedom. Shows that TV channels protected by Article 10. Access to public information. Quite recently, European Court stepped away for its previous views and said that expression is not violation. My time is finishing. Next slide. Orlovska Iskra against Rata. Campaigning or not campaigning? That was the question asked in this case. An ordinary newspaper during election process wrote an article, published an article about one of the candidates who was taking part in the electoral process and commented his actions negatively. This publication was defined as campaigning, but authorities later courts confirmed it. But the problem was, according to domestic legislation of Russia, in such cases, one would have shown who ordered this campaigning material. On the one hand, European Court agreed that this requirement to indicate who ordered this campaigning material is well-founded. It is a limitation of freedom of expression, but justified limitation, taking into account the need to preserve free expression of will. However, the question was that the author of this article said, it's not our campaigning, it's our everyday work.
Досить розмитими, і відповідно не було чіткості для визначення.
So there were no clear criteria to somehow separate the everyday work, even during the elections, just ordinary work of mass media and the campaigning. So respectively, Russia was found in violation. Yes, I'm about to finish. It's just one more slide to go. Yeah, maybe you'll have an opportunity to continue, but Mr. Pachenko is now online. He has very limited time. You don't mind, I hope? Yes, thank you very much. Once again, our apologies. So now we have online the People's Deputy of the Parliament, the Chair of the Committee for Rules of Procedure, and Deputy's Ethics. Unfortunately, there are some interferences. I cannot hear well. So yes, the request is to make it short. Yes, thank you very much, Oleno. I really apologize. I'm sorry, Galina, for interfering with your presentations. I would be pleased to hear it myself. I'd like to talk about European standards for purposes of resolution of electoral deputies. The difficulty of electoral process consists in complexity of such disputes, and various commission mentioned that in one of their fundamental documents adopted in October last year. As they say, this is part of normal political life in a country which is a component of political systems. So this is a key element to ensure confidence in electoral processes. We know that in the national legislative systems, if there is a requirement for them to be effective in resolution of electoral disputes, there were a number of judgments of European Court with this regard. And actually, the interesting point is that these statements apply to both states with transitional democracy and well-established democracy. Let me remind you a story when the Constitutional Court insisted in Austria in 2016 to have the second or the third round of the presidential elections, which actually was the case in Ukraine in 2005. Another judgment that I'd like to mention is the judgment versus Belgium about violation of the applicant's right under the Article 13. And the point was that his complaint was considered by an authority that could not guarantee unbiased consideration. There is another judgment of European Court concerning the single approaches, standard approaches about evaluation of the mechanism of protection of electoral rights in both established democracy and new democracy countries. The Venice Commission also delivered some opinions as the third party that they could refer to their statements, which clearly indicates that they need to have a comprehensive approach to application of the standards to comply with all requirements of both international and national law, maybe international agreements or judgments of international courts. So these provisions need to be the basis for development of further legislation and the basis for actual application of such legislation. One of the sources of such law are the documents of Venice Commission, which actually are rather soft law, and also I mentioned the experience of solution of electoral disputes, which was summarizing documents of Venice Commission experience with consideration of positions of the European Court. I believe that the procedural law of Ukraine regulated the procedure of challenging the results of the election actually meets the European standards. Well, on the other hand, the opinion of the Venice Commission mentioned the notion of effective consideration, and they stated that the the circumstances of any specific complaint cannot be covered fully by the law. So there are some obstacles towards filing application, which actually prevents the national courts from considering the cases on the merits. I think that we should consider for this purpose the extrajudicial means of consideration of such complaints. Now that's a very robust, too robust mechanism, and since last year the situation even got worse. Another point of Venice Commission with this respect is an opportunity for the competent authority to resolve a dispute and the right to cancel the decision of the Electoral Commission. Actually, this is the principle applied by the Constitutional Court of Austria in 2016. It's clear that the Venice Commission certainly expresses their concern against abuse of such opportunity, because otherwise the electoral process will be left without any protection. But the Venice Commission believes that in view of the extreme effect of any judgment of this kind, it could be delivered only in exceptional cases where the evidence of biased approach is clearly established. I need to say that the problem of declaring the elections as unlawful, or you remember the Ukrainian legislation where there were wide discretional powers of the Electoral Commission to declare the results of elections unlawful or invalid. But we remember that this situation led to the situation where the European Court found Ukraine guilty of violating Article 3 of the Convention. On the other hand, if we look at the case law with regard to local elections, there were many cases when the elections were cancelled or declared invalid, and that sometimes may be the only effective way to protect the violated rights. The situation may be that contrary to any judicial decisions, the Electoral Commission refuses to register any candidates or accepts the documents which clearly contain some false or misinformation about the candidates. So here there is a wide space to really improve and enhance this set of legal institutions in Ukraine with this regard. So this institution of declaring the results of election invalid or cancelling them seems to be something that we need to really consider very seriously. Thank you for your attention. Thank you very much for finding the time to get in touch with us with such an interesting topic. So we are now getting back to Irina Kushner. who was, yes, interrupted, but because of some good reasons. But we don't want you to feel deprived of your rights. Yeah, I did just a minute, just a minute. Just a minute and I will finish. And I apologize for maybe going too much time. The next slide, you can see the name of the case versus Hungary. All of you who are interested in this freedom of expression, I invite you to read it. It's about the platforms to exchange opinion, to express opinions. This is a political party which was held liable for their activities when during the referendum, before the referendum, this party took the liberty to create an app for a mobile phone, and they used this app to urge all the people to spoil the ballots, to photograph the ballots, and to send the photos to this app. Actually, they stated that it has nothing to do with the freedom of expression. We just actually gave the people an opportunity to take pictures, to photograph the spoiled ballots. European court disagreed with that because they created the platform to exchange such information, and in combination with this app, the party actually urged the people not to vote, to spoil their ballots. So in this way, undermining the election. The next slide, number 13. This is the name of the Turkish case, Sümergüzey versus Turkey. In that case, it's also a very extraordinary case. A leader of a pro-Kurd political party did not interfere into the speech of the member of this party at the Congress, and that member of the party used Kurd language. At that time, it was prohibited in Turkey and entailed criminal liability. But the applicant didn't do anything. The speaker used that language, and actually the applicant did not interfere. When, during consideration of his case, he said that it was not that I was not just interfering. I was trying to support the idea that the Kurd language can be used if an individual defends the interests of the Kurd people. But this was not taken into consideration by the national authority. The Europeans should agree that this form of passive behavior might be a way to express a view in combination of the arguments that were pronounced by the speaker. It certainly indicated positive attitude to Kurd language. And just to finish, in the cases on the slide number 15, this is a Ukrainian case where European case found Ukraine guilty at the Center of Information Democracy versus Ukraine about the access to public information in the electoral process. The applicants requested biographies of the candidates. They just wanted to read what they submitted to the Electoral Commission, and the candidates refused to share these biographies with them. And that was clear violation of the right to access to public information. That's very important judgment for Ukraine, because according to our national law, if an applicant wants a public information, he or she doesn't need to mention why they would need. So here, the goal of this request was requested, but actually the applicants didn't mention any goal, and the Ukrainian government said that in view of absence of this goal, this information cannot be shared with them. The European Court disagreed with them because this could not constitute grounds for refusal. Further on in the courts, the applicants clearly stated their motives, which was clearly correlated with the Article 10 of the Convention. So, in the national case law, we need to be very careful about these points for purposes of this resolution, and I really apologize for extra time that I took. Yes, we also are very thankful to you for your topic, for your speech, because we are always ready to listen to you, especially when it's about the enhancement of knowledge of our judges, so that they can also be guided in their work by what can be deducted from the judgments of European Court. Another speaker that we have is Mr. Alexander Vadyadik of National Council for Legal Matters for OSCE projects in Ukraine. Actually, he will talk about the gender aspects of electoral process. Please, can you kindly put my presentation on? The idea of democracy and democratic values is always a paradigm for the whole European Convention on Protection of Human Rights and Fundamental Freedoms. If we can look at the next slide. So the purpose of my presentation is to take this concept and to show the place of gender elements for democracy within their meaning in the Convention and the case law European Court, to demonstrate the approach of European judges, national judges, to these matters within the framework of democracy, and that would be the basis then to show the gender dimension of this concept to ensure equality of men and women. I'd like to draw your attention to quite an interesting development by some regional courts of the German lands to show significant variety in their legal opinions. So the concept of democracy in the Convention and the court case law, if we look at the preparatory materials of the European Convention, we'll find a lot of places where the founders would refer to democracy, to democratic society. The Convention, among others, was developed to prevent any return to totalitarian state and dictatorship, and the Convention has become the legal code for democracy. This is a very important point when we talk about the Convention, because this idea of democratic society and democracy as depicted in the Convention text, in particular in its preamble, was built as a point against totalitarianism, which actually led to horrors of the World War II Actually, the authors have a clear vision of what is democracy, how it should be implemented by the member states. But from the European Court, we can deduct two key points about this understanding: pluralistic and representative.
В справі Горзелі та інші проти Польщі.
In Gordelli versus Poland, in this case, court ruled that pluralism is understood as clear understanding and respect to versatility and dynamics of cultural condition, cultural identity, religious convictions, art, political, economic conceptions and ideas. Representative democracy in its sense means formal coercion of authority of majority. On the one hand, but on the other hand, requires effective mechanism of protection of minorities, ensuring equal rights of all people in election process. As European Court ruled many times in its court, starting from part Liberal Party against Great Britain, Convention doesn't require particular electoral system in a country, but it requires compliance with the principle, with the safeguards, according to which total number of votes for each candidate or group should be reflected in the structure of legislative assembly. Both majoritarian systems that exist in many countries and proportional system are compatible with the requirement of Article 3 of the Convention. As I have mentioned, alongside with that, concept of democracy in case law of European courts has a relativist nature that esteemed Dmitry Tretьяков mentioned. European Court always take into account concrete historic circumstances, experience of democracy of a particular state. It's quite clear after World War II, when Europe was living through in post-traumatic syndrome after what happened from 1939 to 1945, when European Convention was drafted, already people knew what was happening in countries when authoritarian Nazi regimes came to power. Drafters of conventions tried to find an antidote to repetition of what happened. Never again. That was the main idea of the post-war democracy. It was reflected in European Convention of Human Rights. At the same time, drafters of the convention understood that perception of liberal democracy that ruled before World War II, that saw democracy through prism of representation, mechanism of representation, people, providing people possibility to resolve their problems by electing individuals that get together to fulfill the will of people. This idea is very dangerous. Democracy is not so much this. And now, 80 years after constitutional democracy was established in post-war Europe, in Germany in particular, we can speak about kind of consensus, understanding of democracy in Schumpeter's sense, according to which democratic methods mean such a democratic order when an individual has the right to make decisions through competitive struggle for votes of electorate. This understanding found its reflection in numerous modern documents, including documents of Council of Europe, OSCE, United Nations, according to which modern political democracy is understood as a system of governance where rulers or leaders of state are responsible for their actions in political sphere to the citizens who act through competition and cooperation of their representatives. This understanding is a starting point for our discussion of gender dimension of democracy, how it is understood in the case law of European Court of Human Rights. When we say about representation element of democracy concept, this representative element requires substantive equality of opportunities, equal opportunities for all, irrespective of sex, and correction of historic injustices pertaining to societies. Based on this principle of representation comes the idea of correcting historic injustice regarding representation of women. I will not go to history. It requires a long time how general suffrage became real. In general, women fought for the idea to elect and be elected, but from point of view of understanding of democracy, how European Court sees this, how democracy is seen in jurisprudence of European constitutional courts, element of representative democracy requires substantive equality, and substantive equality in its gender dimension requires ensuring equal opportunities for men and women. How could we achieve it? Now, the most effective method to ensure gender equality remains gender quotas. Moreover, recent reports of OECD and the Venice Commission indicate that the most effective mechanism to ensure gender equality in political process is so-called zipper mode, system of forming electoral lists, according to which after each representative one gender, representative other gender should follow. If at the head of electoral list is a woman, number 2 should be man, number 3 woman, number 4 men, so on. This system is quite advanced. We shall come back to it later. But taking into account general experience of countries, we can conclude that 117 countries have gender quotas. There are 3 types of gender quotas. In many countries, they exist in parallel. In Ukraine, starting from 2013, there is a voluntary quota for representation of women, 30% and more. In that case, political parties get additional funding. Starting from last year, we introduced an electoral quota at the level 40% of women. So number 1 and number 3 forms of gender quotas are applied. First form, coming back to it, to the system of quotas. Legislation establishes mandatory ratio of men and women in list of political parties at elections. Such system functions in 60 countries. Second form means that seats are reserved for representatives of a particular gender. This system functions in 36 countries. Third type, which is most spread, voluntary party quotas applied voluntarily by political parties. 37 countries of the world have this quota. European Court of Human Rights jurisprudence had examples of cases with quotas. Zevrik versus Slovenia, an interesting case referring to refusal of Central Election Commission of Slovenia to register the list, party list, where representation of women was less than required by the law. What was peculiar of this case? Party was not allowed to correct this mistake. And in this way, this case is even more interesting from the point of view principle of proportionality. If we remember other cases mentioned by Metrotetikov, there the court found violation if parties were not allowed to correct these mistakes in the list in due time. In the mentioned case, the court agreed that decision to refuse registration of party list because of violation of gender balance was justified in democratic society. Another interesting case is pending, Slovenian case, Pechnik and others versus Slovenia, regarding refusal of registration of party list, which consisted only of women. It would be interesting to see how European courts will rule, whether it will follow the practice of established values or changes, refines its approach based on the general objective to ensure gender balance in politics. Next slide. This is quite an interesting development of events in European space. It allows us to conclude that modern understanding of democracy in European court, in jurisprudence of European court, contains a very important gender element that must be ensured through providing men and women of equal opportunities, but take into account historical background that previously women were underrepresented, to introduce gender quotas. That would be good if last time certain deviation did happen from the side which was not expected at all. What I mean, judgments of two constitutional courts of German lands, Brandenburg and Thuringia, that rules unconstitutional the laws on gender parity introduced for elections in these lands. That included this zipper system. Then, in the party list, representative one gender must be followed by the representative of opposite sex. In these two constitutional courts, this system was complained by one of the political parties, right-wing, Alternative for Germany. And in both cases, Constitutional Court rules that laws on gender parity are not in compliance with the constitution of the land. They violate political rights of political parties, right to compile electoral list, and the right of voters, free expression of will without interference of the state. It's interesting that Constitutional Court of Thuringia also judge how its position is correlated with the position of European Court, Zemnik versus Slovenia case, because Zemnik was ruled in 2019 and Constitutional Court made its ruling in 2020. So they found a kind of loophole, that a substantiation, saying that position of Thuringia Constitutional Court doesn't run counter to European Court position. European Court referred directly to the documents of Council of Europe, to which quotas are not counted to political rights. And based on that, Constitutional Court of Turingi made this maneuver, what in English literature is called distinguished cases, differentiated two precedents, introduced in the justice outside the line of jurisprudence established by European Court of Human Rights. This development of events is very dangerous because we see a kind of erosion of general European consensus regarding understanding of democracy, certain deviation from understanding of principle of representation embodied in the concept of representative democracy. I do not exclude that at a certain moment in time, this issue will be raised to European Court of Human Rights again, and accordingly, the court will face a very serious dilemma to find approaches to remove certain contradiction between principle of democracy and gender equality. Anyway, the last word in Germany will be Federal Constitutional Court of Germany. And we hope that Federal Constitutional Court, as always, will be an important landmark for development constitutional practice within Germany and other countries, including Ukraine. They will find the possibility how to formulate proper understanding and to correct this paradox of correlation between democracy and ensuring gender equality. Thank you for your attention. Thank you. Thank you very much, Mr. Vodyanenko. It's really a very interesting topic. I think you know our domestic case law regarding electoral cases. This topic was raised there. It is not resolved finally yet. What we heard from you will be taken into account. We shall review once again judgment of European Court that you referred to now. We are very thankful to you. According to our previous agreement, we decided that after end of presentation, we shall give participants the possibility to ask questions, and speaker will provide answers to the questions. We got a question to Yuri Klitschkowski. Mr. Klitschkowski, are you ready to provide the answer? Yes, yes. Please. But take into account the fact that time that is left very little. The question was whether it was filed to codify the law on Central Election Commission and law on voters list, because they regulate relations not only during elections, but in the period between elections. First of all, it doesn't regulate only the issues during election, like number of members of council, composition of convention, the way the mandates are filed. So the code regulates the issue not pertaining to electoral process as such, but for the period in between elections. Same pertains to law on Central Election Commission voters list. Article 42 of the law on referendum says that powers of Central Election Commission are defined not only by this law, but by other laws of Ukraine, including Electoral Code of Ukraine. And Article 38 of the law on referendum has a direct reference to Electoral Code. I don't see any obstacles that will not allow to leave certain material within the law on referendum and other things to regulate in electoral code to avoid this acute problem when resolving collisions, which norms should be given preference if they don't agree. What has a supreme force, the code or specific law? And we already saw in practice that it gives no good result. Okay. Thank you very much. Mikhailo Smukovich, you had a comment.
В першу чергу я хочу всім доповідачам.
Yes, thank you very much. First of all, I'd like to tell to the audience on behalf, to thank the audience on behalf of Judiciary for very informative and useful presentations, specifically about the administrative courts when resolving electoral disputes. But my first request to all of you would be, in connection with our election code, if Yuri Bogdanovich agrees, I understand there is a working group in the parliament improving the electoral code, but if we create a cassation, a working group with your cassation court, thus the Supreme Court could share some recommendations with the Parliament concerning the enhancement of the election code. I think that would be kind of an important step that would be probably understood by the people's deputies. Talking about Mr. Tretyakov, Kushner, and Medyannikov's presentations, my request to you would be to share with our organizational committee maybe a dozen of key judgments on these subject matters so that we can create kind of a collections, summaries maybe of these judgments of European Court in connection with respective practices so that they can use them here, being better armed for judicial decisions. The case mentioned about the Center of Democracy and Rule of Law versus Ukraine was mentioned. Yes, it was considered by High Administrative Court at that point of time. It was about failure by the candidates to share their personal data with the voters, and actually the judgment of European Court fully coincided with my position, but at the time I couldn't persuade my colleagues. Alexander Vedyanikov tackled with a very interesting point about this, with the active or passive electoral law. It's about violation of principle of equality of the elections. That's very important. That will be very important judgment by European Court, especially with respect to the party where only women were members. I think here we need to considering maybe some potential changes to the Constitution, because sooner or later the same question can be asked to the Constitutional Court on whether the principles of the Constitutions with regard to the electoral rights are not violated if we introduce a requirement of 40% of certain gender the representation in the election lists. Yes, this is an important component of democracy, but the electoral rights, active electoral rights of individuals are also an important part of electoral rights. And if a voter believes that two women should be members of the specific local authority, why should we force him or her to vote in a different way? But in general based, we'll certainly present some further proposals based on the results and recommendations of this conference, because these are the matters that really need a lot of time, not just 15 minutes. Thank you all very much. A short announcement, and let me demonstrate it to you. If you can see, this is the paperback proposals of the Supreme Court on protection of electoral rights, and also collection of presentations offered by our speakers. The respective materials are already available at the website of the Supreme Court, and any one of you who is interested may use these materials. And before we make a short break, I'd like to announce that we'll start the second session at 13:30. Its name is Judicial Protection of Electoral Rights of Citizens, and the first speaker will be Justice of Supreme Court, Mr. Sokolov. So we're waiting for all of you back here at 1.